I want to thank you all the medical professionals from around the country for joining us today. We have a variety of doctors, dentists, and medical practitioners on this webinar, and I know that you'll all be happy about the time that you're going to invest with us. You'll end the session with a priceless strategy to protect not only your personal property, but of course your practices and all of your investments under one simple strategy. For the next 50 minutes, you will be with our team's trusted attorney, Mr. Bob Bloom. Bob Bloom has been an attorney for nearly 30 years and is one of the nation's leading asset protection strategists. Bob spent several years as a trial attorney and is represented in court and a number of Fortune 500 companies, as well as smaller privately held businesses and real estate investors. Having seen firsthand how devastating a lawsuit can be, Bob turned his attention to protecting people and their businesses from the threat of litigation, specifically our medical professionals. As a speaker, Bob has shared the stage with notable political figures such as President Clinton, President Bush, Margaret Thatcher, Mikhail Gorbachev, and financial figures such as Donald Trump, Jim Cramer, David Bach, Susie Orman, Robert Kiyosaki, and Sharif Medawar. He is the author of several articles on asset protection and is an important contributor to the Asset Protection Handbook, which many of you guys might have, and even newsletters that you guys get. Bob will share his years of insights into how you can protect yourself from lawsuits to help you grow your wealth more quickly and secure your practice. On today's Ultimate Asset Protection webinar, please have a notepad near you so you can write down the structure as Bob presents it. This structure is not presented on any other platform in the nation, and I challenge you to find out another structure that is as simple, as inexpensive, and as safe for you. And now, let me present to you Bob Bloom.
Thank you, Ashley, and it's good to be with everybody. I want to welcome every attendee on our webinar, and I want to mention that just to frame what we're talking about, we have great respect for what you do, those of you in the healing professions, and we call what you do in terms of generating revenue, providing for your families, we call making money offense, because you're always trying to score and do what you need to do in terms of providing quality care to your patients and providing well for your family. And many people think, mistakenly, that this is all there is to it. It's just a matter of doing a good job and being well compensated for doing a good job. But all of you know that offense is only half of the game. The other half of the game is defense. And so for just the next little while during this webinar, I'm going to be talking to you about defense, because it's only half the battle to make it. The other half of the battle is to keep it. And so that is our focus on this webinar, is keeping it. So we're going to be talking about lawsuits and the threat that lawsuits pose. And to start with this, just to remind you of where we've come from, many people look back and realize that there are many, many, many more lawsuits today than there were even 40 years ago. There are many more things that we can all be sued for today. The damage awards are much larger than ever, and this trend is likely to continue. So we have to ask ourselves, what has given rise to this explosion of lawsuits in the last, say, 40 or so years? And there are many, many answers to that, but one very prominent answer has to be the advent of the Internet. The Internet is something that lawyers immediately figured out how to use in order to sue you. An example is this. Have you ever seen this on the Internet? It is a real website. And then there are many, many other websites, such as how to sue a dentist, for example. Can I sue my dentist for malpractice? Can I sue for bad dental work in small claims court? And how do I sue a dentist for malpractice? And of course, these questions are posed by lawyers who are trolling, of course, for clients and suggesting to these clients that they do indeed need to sue their healthcare professional, their chiropractor, their dentist, their doctor, etc. So the Internet is definitely a factor in this proliferation of lawsuits in these recent decades. The problem is this. The internet makes suing people much, much more efficient than it was. This is a website that didn't even exist before the internet, but it is used now when someone wants to sue you for a lawyer to come to this website and do what's called an asset search. Here's a typical assignment. It says this site provides detailed financial information to assist attorneys and clients in determining the economic viability of litigation, which means, in plain English, how much money can we take from you if we sue you? It goes on to say, we identify your bank accounts, brokerage accounts, real property, vehicles, watercraft, aircraft, business affiliations, and other valuable assets to satisfy judgments. So if you own it, they will find it. Now it goes on there, once they see you have something, they want to know how much, and this particular website will tell them every piece of real estate you own, when you bought it, and what you paid for it. In addition, they'll do a nationwide criminal search. They'll find every place you ever lived, your Social Security information, and your current address, and then once they have your current address, they'll go to a free website called Zillow.com and find the county appraised value of your home.
Now, they don't really care what the
Now, here is my point. There are simple, inexpensive things that everyone on this call can do right now to have this asset search come up 0. And if it comes up 0, then believe me, they're going to spend maybe 30, 45 seconds looking at you online. And if it looks like you have nothing, the calculation is, well, what's 30% of 0? 0. There's nothing in it for the lawyer, and they very quickly lose interest. They say this is simply not a candidate for suing. So, as I mentioned, there are simple and very inexpensive things that everyone on this call can do right now to begin to make our assets simply disappear when it comes time for an asset search like this. And so I will cover what those things are, and the good news is they're simple, easy, and very inexpensive. Equity, keep in mind, is what a plaintiff wants. They want the equity in your home. They want the equity in your office building. They want the equity in your equipment. They want the equity in your savings accounts. They want the equity in your trading accounts as well. And so equity, bottom line, is what a plaintiff wants. And so we're going to make the equity appear to disappear. All right, so we're going to talk now about sources of suits for dental professionals, and really this is broad enough in general for any kind of healthcare professional, but our focus on this particular webinar is for dental professionals. And I want to mention that there's a book out now by an attorney named Harvey Silverglade, who entitled it 3 Felonies a Day. And the premise of the book is simply this, that we have so many laws on both the federal and state level today that any honest, hardworking business person or professional is likely to commit what could be considered 3 felonies a day. And while that sounds preposterous, the point is simply this. The laws are so vast, they are so vaguely written today that a law intended for, let's say, X offense can now be stretched to cover Y action. And so unintentionally, you are, in the prosecutor's eyes, committing a felony. And while that's on the criminal side, and we're not going to be talking about criminal law today by any means, the same principle applies when it comes to civil law, meaning that a statute that was intended to prevent this particular type of action is now stretched and really misapplied to your particular action, and you now find yourself liable under the law, under a law, in fact, that was never intended to cover what you did, but it nevertheless does in a court of law today. And so this is one other factor for why we are seeing so many lawsuits in America today as well. So an obvious source of suits is malpractice. There are 1 out of 7 cases of medical malpractice today is brought against a dentist. And an average of 2,280 lawsuits are filed against dentists and their staffs every year, and that's been the average for about the last 10 years. I might add that these malpractice cases produce some very, very high awards. In June 2013, a woman was awarded $350,000 after a root canal led to nerve damage. In the same month and year, a man received an $800,000 settlement after his dentist failed to refer him for further testing for a cancerous tumor under his tongue. And in May of 2013, a dental patient received a $2.69, almost $2.7 million verdict after suffering nerve damage when a drill bit broke off during a wisdom tooth extraction. And in November 2012, a patient was awarded $297,000 after suffering bite problems following the placement of a crown. And in April 2012, a man received a $200,000 verdict because his dentures never fit properly. So these are some very, very serious awards, and they're going up as well. Now, the malpractice can really be divided into a number of subcategories, and one of those is a dentist can be sued for the acts of their professional staff. So, for instance, dental hygienists. I want to give you an example of the case. A 3-year-old boy had had his first visit to the dentist, and the child was examined by the dentist and then was being treated by the dental hygienist after no decay was diagnosed. And the dental hygienist performed just a routine prophylaxis and fluoride treatment. And as the dental hygienist was, turned away, engaged in a conversation, the child drank a cup of water and swallowed all of the fluoride in his mouth. The child was rushed to the hospital, where he lapsed into a coma and died. He had an overdose. It was 3 times the amount of fluoride in his system, and that amount proved to be fatal. And so a dentist, under a principle of vicarious liability, is responsible for the acts of the paraprofessionals under the dentist's supervision. There is a second subcategory, we could say, in malpractice due to equipment failures and medical supplies. So there are radiograph issues, there are anesthesia complications, there are cases brought because of defective equipment. I just read about a drill bit that broke during a root canal. There are adverse drug reactions when someone doesn't perhaps check the patient's medical history and that drug is contraindicated. There are medical product issues, defective medical products that lead to malpractice. Now, keep in mind, the product manufacturer is going to be joined in this suit as well, but often the healthcare professional is a party as well. Another subcategory, of course, is malpractice from the dentist's own acts, and there can be some nerve and sinus perforations, failure to timely diagnose or treat, usually in periodontal cases, mistaken extraction of teeth, instruments left in canals, and even wrongful death, often from serious infections. So malpractice, of course, is something that you insure against, but the problem is you never know how much insurance is enough. And then another problem is if you overinsure, always the first question that a lawyer is going to ask is how much are the insurance limits, the coverage limits. And if you've got a very large coverage limit, you're even more of a target. Breach of confidentiality is another problem. HIPAA rules predominate today, and here's an actual case. There was a hygienist who was treating a longtime patient, and she, was getting a little chatty and it was friendly with his patient. She confided in her that the patient's name that she was talking about and said that she had just been diagnosed with cancer and was going through a terrible divorce. And to the hygienist's horror, the longtime patient announced that that patient was her sister-in-law. I guess it's a small town, small world. You never know who it's going to be. But obviously now we have violated the confidentiality required of a professional, and that dentist is now liable if any harm occurred from that breach of confidentiality. An intentional tort is something that is not necessarily intentional, but is deemed to be intentional. So, for example, the failure to obtain informed consent would be considered an assault, and that in the case of an assault and battery, but this time it's a civil assault. If there's misrepresentation or deceit, overstating the likelihood of success of a procedure, mental distress inflicted upon a patient, to perhaps coerce that patient into accepting some kind of treatment. Employer liability is another issue for any healthcare professional because you employ others in your office. That employee could sue you, the healthcare professional, for wrongful termination, for age discrimination, for sexual harassment, for Americans with Disability Act violations, which are many. There are civil rights violations as well, and so these employment lawsuits can be a source of liability as well. Then, aside from your practice, I want to talk about general liability that everybody shares, whether you're a healthcare professional or not, and one of those, of course, is the threat of divorce. Busy professionals are busy, devoted to their practices, and too often ignore what's probably much more important, and divorce is an ever-present problem. Premises liability, that would be true not only in your office, but in your home. Guest accidents in the home, in any rental properties that you own, premises liability is a major source of suits. There are joint ownership pitfalls. The way we own assets with our loved ones is a major factor. If we own our assets with our spouse or a parent, child, sibling, friend, that is considered joint ownership. And the problem is, under the law today, if someone sues your joint owner and prevails, they can now seize your assets that you own jointly with your joint owner, even though you have done absolutely nothing wrong yourself. So the rule is, get out of joint ownership. There are much, much safer ways for two or more people to own an asset together. The use of general partnerships is a very serious source of liability, because if you are operating with another healthcare professional, and I hope that that's not the case with anyone here on this call, but if you are considered, without a corporation or an LLC or a PLLC, you are now considered to be a general partnership. And the rule is, a partner in a general partnership has unlimited personal liability for the debts of the practice or the business. And so you can go broke for what your partner does wrong. Now, you could, if you have a professional corporation or LLC, you would be considered an officer, very likely, of the company, and you can be sued for what the company may do wrong, because officers and directors of corporations and LLCs as well are liable for what the company may do wrong. Another source of lawsuits is you may not be an officer, but you may look like an officer. This is a case where spouses are often brought into lawsuits. The case of the relatively unsophisticated professional who puts everything in his or her spouse's name, thinking that will keep the assets shielded, the spouse ends up providing services to the business. They write the checks. They're working in the business. They are then viewed as a constructive officer of the business because they look like an officer. They function as an officer even though they're not officially an officer. So that spouse now becomes fully liable as an officer of the company. Just owning an asset can be a source of liability, and that's very dangerous. Just one quick example is if you're the parent of a teenage driver, your teenage driver can't own anything legally until they're a certain age, and so the car they start out driving is titled in your name. And then son or daughter gets into an accident, and you are the one who gets sued because your name is on the title. And the law assumes if you're the title holder, you control who has access to the car. And since you allowed a negligent driver to drive your car, the liable party is now you. So think hard about what titles you have your name on. And that's typically our homes, our vehicles, our bank accounts, our investment accounts. If you're really doing it wrong, investment real estate. And for every one of those assets with your name on the title, you are automatically liable when a lawsuit arises from one of those assets. So the rule for our clients is you get your names off of titles. There are far safer ways to own an asset. A suit today for an act 10 years ago. This is a reference to the statute of limitations, which generally is something that's going to protect you for something that happened maybe years and years ago, except for the great exception, and that is generally that the statute of limitations only begins to run when the harm is discovered. So in these cases, it would be when the sponge that was left in the abdomen after surgery is finally discovered after years of pain. Now the statute of limitations begins to run, and you have no protection as a general rule for what has happened years and years ago. 15, consider this, that insurance may not cover you. The problem is everyone, of course, has professional liability insurance. We should have. The problem is twofold. Number one is you never know how much is adequate coverage. And if you overinsure, that simply attracts lawsuits. And the other problem is that insurance companies are famous for denying a claim. Most of your insurance company or policy, if you read the fine print, is not what they will cover, it's what they won't cover. That's the exclusions. And so, folks, it is imperative that we have a backup protection system beyond just malpractice and professional liability insurance. So remember that equity is what a plaintiff wants. It is what the plaintiff is after. And so what we're going to do is protect the equity. And if the equity is gone or cannot be accessed, you become like a piñata without the candy. In other words, there's nothing there for the plaintiff to take. So how are we going to do that? We're going to apply some very important principles of lawsuit protection, and I'd like to illustrate it by an analogy. Let's assume you have a home, something we're all familiar with, and we have a fair market value of, let's say, $100,000 in the home. But the bank has a mortgage for, or you have a mortgage for $100,000. So the question is, how much equity is there? None, because any equity in the bank really belongs to, any equity in the home, I meant to say, really belongs to the bank. So how much equity is there? None, because any equity in the property really belongs to the bank. In other words, the bank has a lien on the property. It's called a mortgage, and we're all familiar with that. So let's do this another way. Let's say you have a fair market value of $100,000 in the property. The bank has that lien or a mortgage for $100,000, and the result is there's simply no equity. So let's take this one step further. And by the way, if this were the only asset that you had and someone was interested in suing you, they would quickly lose interest because there's nothing there. There is no equity. There's nothing to take. So to take it one step further, here we are. Let's assume we have $100,000 of equity in the property, and instead of the bank having the lien, let's create a brand new LLC, which is formed properly in the proper state, and we'll get into that in a minute. This new LLC is something that has to be capitalized at its formation, and so you pledge the equity in the property, the $100,000, to capitalize the LLC. Now, a pledge is a promise to pay. It's not an actual payment. And so, because it's a promise to pay, we have a promissory note to memorialize this promise. So we have a note in the LLC which is worth $100,000, so to speak. That means that the LLC has the right to place a lien against the property to secure the promissory note for $100,000. In this instance, there is no equity, because any equity in the property has a first lien on it, which has been perfected by recording it. So how do we protect our property? Well, we have equity in our home. We have equity in perhaps real estate we own, maybe the building in which you practice. We have professional equipment, considered in this case business assets. We have personal property, such as savings, checking accounts, investment accounts, stocks, bonds, mutual funds, a lot of very important assets, all of which have positive equity. And so how do we protect that equity? Well, once again, we create an LLC properly drafted with a very specific operating agreement with key words in it. We are the owners of the LLC. We pledge the equity in these assets to capitalize the LLC. The LLC holds a promissory note evidencing that pledge. And as a result, the LLC, based on the promissory note, now secures payment of the note with liens against the assets. And so there is no equity in any of these assets. Now, in order to do this, what this means is when there is an asset search, now it comes up zero. There is no equity. Of course, it'll show you may have title to these properties, but when the equity is searched, it comes up zero. And because there is no equity in any of the assets, the plaintiff's lawyer, working on a contingency fee basis, figures 30% of zero, I'm not interested. And because the plaintiff will never find a lawyer willing to take that case, and because the plaintiff will be told, even if we win, there's nothing in it for you, there won't be a recovery, the plaintiff quickly loses interest in suing you as well. So equity is what a plaintiff wants, and there simply is no equity. And when there is no equity, that means that you are much, much less likely to ever be sued. Now, one question that I know many of you are thinking of is, but what about the fact that I own the LLC? Couldn't they just sue me and then get the promissory note? And therefore, don't they have the lien? And the answer is no, they do not. And here's why. It's because of that unique entity that we're going to set up called a limited liability company, but not all limited liability companies are created equal. They must be formed in the proper state and with the right keywords. I'll give you an example. The proper state is this. The first state to create an LLC is the state of Wyoming. That was in the year 1977. There was no other state that even adopted LLCs for many, many years because nobody knew how these entities were going to be taxed. And then finally that issue was resolved, and then slowly states began to adopt LLCs. And so Wyoming was the leader and has always been the leader in LLC law as the very first state to create an LLC and as the state to give the LLC the most protection as well. So here's what we do. We form an LLC in the state of Wyoming. That is only part of it. There is a second document called an operating agreement which are really like the bylaws of a corporation. It shows the rules of how that a limited liability company is going to be operated. So that must have very specific key words in order for this limited liability company concept to work. We have the LLC formed now with the right keywords in the operating agreement, and now the LLC holds the promissory note. In other words, it's one of the signatories to the promissory note. It's the promisee. And so the equity has been pledged to the LLC to capitalize the LLC, and that's memorialized by a note. Now, you may say, well, so what? Why does that protect? And the answer is because the LLC is a unique entity which comes with something called a charging order. Let me explain. A charging order is basically a lien that a judgment creditor gets. Now, the term judgment creditor means someone who sued you and wins the lawsuit. So this is the remedy, this is the prize that the winner of the lawsuit or judgment creditor gets for suing you, and it's a terrible lien. It's a lien against your ownership interest, and it gives them virtually nothing except a major headache, and let me explain. First of all, the charging order as the exclusive remedy for suing a member of a Wyoming LLC says the winner of the lawsuit will get 3 giant migraine headaches, and here they are. Number one, the winner of the lawsuit is entitled to receive a certain percentage of your assets from the LLC. And the exact percentage they get to seize every time by law is 0. They cannot seize, attach, or levy upon that promissory note in the LLC, and that is the law of the land if you use that tool. So, in other words, the promissory note is safe and secure within the LLC. No one can sue you and take the promissory note, all right? The second thing they get as a result of winning the lawsuit is they get the right to receive a certain amount of net income that you distribute from the limited liability company each year. So in other words, they can't take the assets in the LLC, but they can take the income from the LLC that you distribute. Well, the reality is this. We have drafted the operating agreement in such a way that the amount you will distribute is 0. And so if you distribute no income, they will get no income. And so they've come up empty-handed for suing you, spending all this time and money. They've gotten no assets. They've gotten no income, but the best is yet to come. And that's number 3. Because in the year 1977, the IRS issued one of the most famous revenue rulings of all time, and it's known as Revenue Ruling 77-137. And it basically says this: we don't care that the winner of the lawsuit may have won a judgment against you for, say, $2 million, but they couldn't figure out how to get the $2 million from you. They got no assets and no income. The IRS says we don't care. But even though the winner of the lawsuit got nothing from you, the winner of the lawsuit still must pay income taxes on the $2 million you never gave them. And you've got to ask yourself, if you're the plaintiff or the plaintiff's lawyer thinking about suing the healthcare professional and they're going to get no assets for winning, no income for winning, and instead they're going to get a tax bill on the amount they never got, the reality is no one in their right mind would ever want to sue you when this is the result. And this is the result mandated in Wyoming statutory law. So that's as good as it gets and as strong as it gets. So here's what happens. When you own the LLC, you are considered the member of the LLC, and when they sue you, the result is you are protected. The assets in the LLC are protected, and that means that promissory note is safe and secure in the LLC. That is a beautiful, beautiful result. Now, I have been a lawyer for 30 years. Next year, 30-year anniversary coming up. And I have drafted many, many asset protection plans for many, many people. This is just an example, but as you can see, there are many moving parts. There are a lot of filing fees. There are a lot of there's a lot of movement and moving parts between these different entities. They all have annual fees. Many of them are going to have registered agent fees, and that can be costly. It can be difficult to administer. It can be complicated. And many people with structures like this often say, I just can't administer it. It's just too much. And so the beauty of putting friendly liens on your assets and removing the equity is it is simple, it is easy to operate, and it is very inexpensive by comparison. Very, very good approach. So how are we going to proceed? Well, we have an ultimate asset protection package, and I want to share it with you. Here's what we do. Your LLC is set up in Wyoming, which is the very first state to ever create an LLC in the United States, and it remains a leader in limited liability company law. Second thing is your operating agreement has key words providing a business reason to exist beyond simply asset protection. And you will make only one interest-only payment per year under the promissory note. You have full control to cancel or write off or subordinate the note. If, for instance, you wanted to obtain a loan on one of these properties, you can cancel the note, or you can subordinate the note to second position to your lender making the loan. And then fifth, there are no ongoing legal fees to maintain the structure. It is a very simple and inexpensive approach. So once again, you can do it the hard way, you can do it the easy way. But here's what we do. First of all, we provide that custom Wyoming limited liability company for you. We provide the operating agreement with all the right key words that must be there that requires very, very careful drafting. And that is a $3,300 value because this is not a run-of-the-mill, everyday kind of limited liability company. It's a very specialized kind of limited liability company. Third, we provide custom promissory notes to encumber the equity in the assets we want to protect. And that's a $1,500 value because that promissory note is commercial paper. It is a very valuable promissory note and must be drafted correctly as well. We'll fourth, provide limited liability company ownership certificates, which you will need to prove your ownership of the LLC, and that's a $500 value. We'll provide a lien for filing. And so that lien it's either going to be a UCC1 or other lien. That'll be a $1,250 value, and we will then provide registered agent service for 1 year, which is a $450 value as well, and we will provide 1 year of hotline support as well. And that is a $2,500 value because we'll be standing by ready to answer your questions at your request. So we will be there for you. I want to encourage you, if this sounds at all important or interesting to you, if you've been looking for a way to protect your assets, to take action now to get started and to protect your practice. Vitally important, you protect your practice, you protect your personal assets, you protect your family's assets. So let's review very quickly. What's the asset protection package? First of all, we provide the custom Wyoming limited liability company filing in Wyoming to take advantage of that outstanding Wyoming law. Then we provide the operating agreement with all the keywords, and together that is a $3,300 value. Third, we provide the custom promissory notes to encumber the property, $1,500 value. We provide the limited liability company ownership certificates. We provide the lien for filing, critically important, which is what protects the secures the property, then, or the note, and then we provide registered agent service in the state of Wyoming for an entire year, and we will also provide 1 year of hotline support. So if you have any questions, please call us, email, we will hold your hand, what to do and how to do it. That is a $9,500 value. Now, people will look at that and say, well, gee, I guess I could do it this way, which will cost a whole lot more than $9,500 and will be much more expensive to maintain year by year, or we can do it for $9,500, and that is the value. Now, the good news is, on our call at this time, on this webinar, we're providing a major discount of roughly $5,000, and that is a $4,995 discounted price. On our webinar today, we are providing a major discount, and that is the price is not $9,500, even though that's the value. We are providing this for $4,995 at a discounted price. And the reason we can do that is we've done many, many of these. We've achieved economies of scale. We've become very efficient at doing it, and so we are able to pass those savings on to you. And so that is a $4,995 price as the result of our webinar at this time. Now, we're going to provide a bonus for those of you who get the Ultimate Asset Protection Package, and that is a living trust, which avoids probate. This is a bit of estate planning, and that's normally a $1,200 value, but we can do that and will do that for you at a tremendously low price of $99. So if you do not have a living trust to protect your family from probate, by all means, this is a wonderful way to get it. So we have 6 appointment slots if anyone would like to call in. Many of you know you need to do this right now, and so just call and just get it started. For those of you who are not quite sure, I want to offer these appointment slots over the next couple of days, and I think it's important that you understand the value of your actual practice and the assets that you have. And many people have a rough general idea of that, but part of the package gives you access to our office to help you determine the actual value of your business or your practice and of your assets as well. That's critical because we need to know how much to pledge, how much equity is there in order to pledge it and protect it. So as part of the package, call in. We will provide that help to you as well. Now, we've been talking about adequate capitalization of these of the LLC when it's formed. We have many, many clients with a very high net worth, and they have the same kind of concern. So the Sharif offers a credit line from one of our corporations that holds millions of dollars in assets in cash, and Sharif can show that the credit line is secured against your LLC in Wyoming with special wording to show that at the time of formation, the credit line was extended and secured against your capitalization amount. So we keep this credit line documents and formality for 24 months, and then we can cancel the credit line. So once again, overcapitalization has never been the issue in the legal sense. It's undercapitalization. So use that credit line if you need to adequately capitalize your business and your practice. All right, so we have these 6 appointment slots. If you're interested in any of the various many offerings that we've made, many of the things that are imperative that we do, I'd encourage you to call now and reserve a spot or send an email to us. Now, Sharif is wonderful at teaching his students how to invest, how to generate wealth, which is offense. Many of you are well-compensated professionals. You have a good offense. What I have just talked to you today about is often the missing piece of the puzzle, and that's defense. When you combine what Sharif can teach you, what you already do in your practice, which is offense, with the defense that I've explained to you here today, now you have significantly more money, you have financial security finally, and you finally have peace of mind. And you've got to ask yourself, what in the world is that worth to you? And for many people, the answer is that is simply priceless. So one of our students summed it up by saying, the most important thing is knowing that my wife and kids are protected forever. And I think that is exactly what it's all about. So I want to encourage you to get your asset protection now, take action now to get started and protect your practice, protect your personal assets, protect your families from probate as well with that living trust offer. And so I want to thank you for your kind attention on this webinar, and I'll look forward to talking with you as you make your appointments to call in. Thank you.